Not at the moment.
Okay. Then we have a request for an extension of time for a prior approval. I don't know if there's counsel here to represent, I expected it would be Mr. Daly or Steve Surratt.
It should be either one of them, and they're not here, Mr. Chairman. You could move it to later on the agenda. Maybe they are stuck in traffic.
Okay.
So moved.
We'll defer that one till later in the meeting. Next item of business is a public hearing on Indian Rock Farm Road parcel. It is a preliminary plan approval with Unified Development Review for Plat Y4, Lot 4, 707 Point Judith Road, and I think this might be Mr. Garrity from
Yes, Mr. Chairman, members of the board.
and I think the purpose of tonight, as I get it from your correspondence, is to seek the planning board's concurrence that we have jurisdiction at this point in time to consider this matter. Is that correct?
Yeah, no, well, Mr. Chairman, I think what we'd like to do is just continue the matter this evening till next week. My experts are not
Next
here.
month, you mean? Next month,
I'm sorry,
Yeah.
next month. Yes, so with your permission, we'd like to do that. We've had a chance to talk to your council. We'd like to talk again. Mr. Craven's not here. We'd like the ability to talk to him a little further about the matter and then consider the matter next month.
Okay. Is there any objection amongst the board? They have a motion?
Yep, move to continue.
Date certain, to a date certain.
March 17th.
Can we do that? Well, Jill, yeah, you know the program here.
Yes, we can.
We can.
Okay. Okay, so there's a motion to continue this matter until March 17th. Is there a second?
Second it.
Mr. Garrity, would you prefer another date?
No, I would not, Mr. Chairman, it's St. Patrick's Day, but it was still, I'll be here.
You know that? You know that? I know that.
I'll be here.
All in favor?
Aye.
Thank you very much.
Okay.
Mr. Chairman?
Yes.
I'm sorry to
Thank you, everybody.
interrupt. Alicia's done.
Good
I
night.
think we can let her go. She doesn't need to stay for the rest of the
Boy,
meeting.
Alicia, this was an easy one tonight, huh?
Oh my God.
Okay. You're free to
Yeah.
go.
I'll pack up nice and quiet.
I was kidding you when I came in. Yeah. Quick night.
Can we get the minutes first thing in the morning?
I need to interrupt you.
Oh, thank you.
Oh, no, that's okay.
Okay, then our next order of business is item D1, the zoning ordinance amendment to section 9.1. Paragraph 2, non-conforming uses and structures and continuances. This was a matter that was brought to us last month by Mr. Green.
Evening, Mr. Chairman.
You're back again. And I guess before, just as part of your lead up on this, Jack, two things I can think of for me that would be helpful, and I think for the rest of the board. One is just to describe the outcome and whatever changes came out of the working group meeting that everyone left to go do. And then second, if there have been any further changes since the working group meeting, describe those changes and what the purpose behind those changes.
Little notes out.
See you, Alicia.
Bye, thank you.
If you prefer to handle it a little different way, Jack. and
Yeah,
come back to it,
I'm looking at my notes from the thing. I think after I submitted and we went over, I think Bill Landry may have sent a few additional comments in. I think one was a typographical error where I said special use permit, when it should have just said permit. I think I changed a shall to a may. I think Mr. Friday had mentioned, we were going through the whole thing, we changed, I think we missed one, so I changed shall to a may. But did you have a copy of the most
I
recent
do.
one?
I think all the board members have.
And,
it part of the
okay,
package.
so, yeah, so, basically, we sat down, we had a pretty good meeting with Mr. Grundy and Mr. Friday. We went through it, fine tooth comb. I don't think in terms of the language, we separated out section 9.1 from 9.2 because the original ordinance kind of, merged together dimensional nonconformity with use nonconformity. It was very confusing. So I broke it out just from a wordsmith standpoint, just to make it clearer. We changed several of these spots from shall to may. That's what really caused the Supreme Court to say that particular language was mandatory and not just mere zoning requirement. It was an express condition. So they took the position that since it's an express condition, if you want to do that, you're going to have to amend the zoning ordinance to permit somebody that has a legal non-conforming lot of record to do a voluntary demolition and be able to go in and ask for the dimensional relief. So the zoning board's taking the position, until we make this change, they don't have a jurisdiction to consider it. And that's what that Wesley case said, that because of the language present in the Wesley case, which is pretty similar to what's in the Narragansett zoning ordinance, we'll need to amend this ordinance to permit, again, somebody that has a legal non-conforming lot of record that voluntarily demolishes that house, would give them the right to go in and request for dimensional relief. And that's actually what my client's doing. Mrs. Martino, she has a raised ranch right across from Scarborough Beach. She wants to knock it down, and basically she's decreasing the dimensional non-conformity on one side and increasing it on the other side, and she's making her house slightly wider. That's why she needs the relief. It was like 1.5 feet, 2 feet, in order to put a wider hallway up the middle of her house. Past practice, we've always been able to do that until the Supreme Court came out and said, no, the language in the Wesley case is mandatory and not merely a zoning requirement, and therefore you have to go in and amend that ordinance, which, like I think I said last time, I don't think the town council meant to do that, because what would happen is right now, if you have a legal non-conforming lot of record that's vacant, and then you have a legal non-conforming lot of record that has a house on it, the person that knocks down the house right now, as it stands now, can't go in and ask for the relief, but the same person with the same size lot right next door would be able to go in and ask for the relief. So I don't think it was the intent of the town council when they passed that ordinance. They probably just weren't thinking about it. And so we went ahead, and it's been redlined. There's not a lot of changes. I know Mr. Landry's office had more of a concern concerning the use portion of the statute, and I know there's an attorney here that may want to briefly speak on that. But I think if there were any changes that were added to after our subcommittee meeting, I think there were a couple of comments by Mr. Landry that we incorporated into, I think it was section 9.2, probably specifically comment section 3 and section 1 and section 3. So if you have any specific questions on the changes that we made and why we made them, I can address those. But other than that, I think the changes speak for themselves. We're just looking for approval to request a dimensional relief if we knock the building down.
So you want the planning board to make a recommendation to the council?
A positive recommendation to the town based on the revised language. So this was a substantial change. So the town council referred it back to this board for further comment, because the changes I initially made were substantial. So they referred it back down here for your final review and recommendation for approval.
So I have questions, others might have questions as well, but before we do that, I don't know if Rupert or Jim, from the point of view of the working group work that you did, is there anything from your vantage point you want
Well,
to
I've
get
got
out
a
right
couple,
now?
but they might be the same as Rupert, so.
Yeah, so I guess I'd like to thank Mr. McGreen for meeting with the subcommittee, and Mr. Grundy and I, Steve Marsalis also was there, along with two assistant solicitors, Craven and Salitra, and Ms. Sabo.
And Mr. Pimentel. Mr. Pimentel.
Mr. Pimentel was at that meeting too, sorry. Anyhow, so we had a good subcommittee meeting. We really, I thought, worked through and had refined it pretty well. In the draft that came out of the subcommittee, the two changes I see, Jack, that I wanted to ask you about on section 9.12, we had added an H, which said the applicant shall have the right to seek relief from the zoning ordinance, and I just wonder,
I don't see an H.
So,
it was in version 5. It was not the one in front of us. It's the version 5 that came out of the subcommittee meeting.
so Mr. Green, when you, after you put together all the commentary, you
Right.
sent out version 5, which had letter H.
Right.
And then after Bill's commentary, you resent it out as version 6, and letter H is missing, is not
Okay.
there.
I don't recall what H said.
It just basically just added another, the applicant shall have the right to seek relief from the zoning ordinance.
I want to be sure I'm looking at the right.
Let me just see.
That's not in the draft in front of you, that's the draft that came out of the
Let me see
subcommittee.
draft.
I guess what I'm saying is there is an H in the.
Oh, yeah.
There
The
is an
applicant
H
shall have the right to seek.
here that I'm looking at, which basically,
There is?
and I want to see, yeah. There's an H. 9.2 says the applicant shall have the right to seek dimensional
Right.
variances, modifications, special use permits, and or staff approval. Is that what you're talking about?
Yeah, that was, I think, the old draft that
So
got marked up.
This language was stricken.
Well, it got revised.
Revised to say what?
To say the applicant shall have the right to seek relief from the zoning ordinance.
And that's under, let me just say for 1 second. That's under the use section, right?
Correct.
Yes. I think that was at the request of Bill Landry to make it clear that you would be able to go in and seek the relief.
Well, we had it in the version after the subcommittee meeting, that was in there.
So the one I have right now, I have a G, I have a co-chair.
Yep.
Just to make sure we're talking about the same. So this is the most recent one.
Yep.
That doesn't have an H.
Yep,
So this one,
yep.
Otherwise, you can't there.
That was in there after the meeting.
that was in there after the meeting?
Yep.
And then it got taken out?
Yep. Just wondered if there was a reason
I wonder if
why.
it was, it could have just got, I mean, I don't have any problem with that language, so it may have been dropped out in error.
Okay.
It may have been dropped out in error.
And then,
Because I'm looking through the notes, I don't see anything from Bill Landry saying, take that out. I don't see why he would.
and then, so the other change I see from the subcommittee is section 9.23. And, and this seems to have a pretty big impact on the meaning. Right now, in the current draft, it reads, if a dimensional non-conforming building or structure is demolished or removed by its owner, it may not be rebuilt or replaced in a way that will result in an increase in any such dimensional non-conformity unless the owner obtains relief from the zoning ordinance. It seems to me that that's writing in that you're grandfathering any existing dimensional nonconformity.
Yeah, I believe that was a request by Bill to add that language. And in his comments that he sent me, I think he forwarded them on to you as well. If you look at his comments to that number 4, it says, this merely reflects existing ordinance per comment number 2 and comment number 3. As noted above, there is no provision in the current ordinance that precludes the appropriate permit, example, staff approval or coastal overlay or building permits, being issued for a demo rebuild where there is no increase in dimensional nonconformity.
So,
So he's just saying that, he's just restating there what he believes is already built into the ordinance.
so is that the current practice? I don't think it is.
No, it isn't. No, I clarified, well, it isn't the current practice. I did clarify with the building official today. I believe you have a copy of his correspondence that came today, where he said, no, that in fact, that's not the current practice. If you want me to just read it for everyone here, I can. Thank And reading the amendment, amended zoning text, section 9.23, the proposed language is in direct conflict with how those permits were handled up to now. If a project was a total voluntary demolition and dimensionally non-conforming, it would need a zoning variance for the non-conforming portions, even if it was rebuilt in kind. The way in which it is written would allow it to be rebuilt even if a dimensional nonconformity, as long as it didn't increase the nonconformity. I recommend keeping that section as it was originally.
And I guess the way I read it is, so, I mean, in the couple of years I've been on the planning board, we give variances for decks all the time. And
Right.
reading it this way, it seems to me that if you were tearing down a house with a deck that had a variance and rebuilding it, you could rebuild the house to the footprint of the deck.
Oh, I see, you're saying take the footprint of the deck and just go up?
Yeah, or replace the deck with a house. It
Right.
just seems like it grandfathers any variance. And
Well, would that be increasing the, let me just read that language again. One second.
And so the language we had before, after the subcommittee meeting was, or replace except in conformity with the dimensional requirements of the zoning ordinance, unless the owner obtains relief. So that reads consistent with what Wayne is saying, I think.
Right.
Yes.
Yeah, so in the version 5, if dimensionally non-conforming building or structure is demolished or removed by its owner, it
Yeah.
may not be rebuilt or replaced except in conformity with the dimensional requirements of this zoning ordinance unless the owner obtains
So-
relief from this zoning ordinance prior to demolition or removal.
So it allows, version 5 allows for them to obtain relief, but it doesn't grandfather in
Yeah,
relief. So I have real concerns with that change. And I don't know, Jim, what your take on it is.
Yeah, there was really two things that I had circled. My concern, I just talked to Joe, was that it could affect fire ratios. It also could bring into question whether or not our relief was reduced, but were you grandfathering what the old relief was? So if someone was, say, 3 feet off of a property line, and the new structure was built 5 feet off the property line, you reduced the nonconformity, but would they have a right to go back to the 3 at some point in the future? Because it would be approved based on this.
Well, and I was thinking about the other project before us tonight, the subdivision that we didn't hear. They have a non-conforming awning over their gas pumps. And I think the way this reads, if they tore down the gas station, the gas pumps, you could build a building to that
For that
non-conforming
lot
awning.
coverage.
Yeah,
mhm.
so those are my concerns with it.
Yeah, like I said, my client is more concerned about the dimensional relief request rather than use. I know Mr. Landry was concerned about, he has an existing project out there that he was concerned that would be affected.
Well, and I sort of feel,
Did you read his letter? Have a chance to?
I sort of feel like he was saying he's worried about the existing approvals, and it feels like section 9.3 that we added takes care of his concerns. That's the way I understood his concerns.
It was just
I don't have a problem going back to those 2 sections in version 5, putting them back in. That wouldn't be considered a major change
So,
to create, it's a minor change,
so, I mean, I can support it if you
Okay.
do that.
I have no problem with
I
that.
don't know how Jim,
I feel the same way. I'm comfortable with those 2 items being as we had in version 5.
yeah.
Yep, version 5, so that is just, I made a notation, so that is under the first page, add the H back in,
Yep,
and on the 3rd page of 9.1, add 9.2, add section 3 back in as it was amended.
yeah,
Okay.
if that's agreeable, yeah.
Jack asserted that it's not a major change. Do you agree with that?
I just missed some of it because we were having a conversation.
No, the modifications that Jack is inclined to agree to, based on the comments that Jim and Rupert have made, Jack has asserted it's not a major change, so it wouldn't have to go back.
I don't think it's so substantive to change the spirit of what is being attempted by Mr. McGreen's client. And it's a gray area. It's always going to be a gray area. Is there a line? It's my opinion that it's not so significant to warrant re-advertising or reposting or anything like that. I think it's a minor change. I agree with Mr. McGreen.
Unless somebody objects, we're going to agree to your opinion. We're going to be guided by your
I'm
opinion.
shocked nobody's jumping up and objecting.
Okay.
And just thank you for agreeing to
thank
meet
you.
with the subcommittee and working with us on
So, Mr. Chairman, can I just clarify and confirm that Mr. McGreen is in agreement to add in letter H under 9.1.2, I
Yes.
believe? And he's also in agreement to change the language for 9.2.3 back to version 5?
Correct.
Thank you.
Correct. So what I'll do, I'll redraft that version. I'll amend it and send it back to you again, okay, before I send it to the clerk's office.
So that's a good question. Because it's already been advertised, it may have to be a strikeout on an addition. I would defer to,
We can talk to the clerk's
Yeah.
office.
Okay. Right. But we can, it'll be a public meeting, so we can open it up and change it as a minor change at the town council meeting.
and it's open, so
Right.
yeah.
Okay. Yep.
Okay. Are there any other questions?
Mr. Chairman, if I may?
You may.
Thank you.
Please identify yourself.
My name is Scott Spear, S-P-E-A-R. I'm a partner of Bill Landry.
Okay.
Bill and his son are together on a trip to Florida for a school vacation week, so he asked me to come down here and see what was going on. I just want to let you know for the record that the changes that you've discussed are acceptable. They were the language that was in the proposal that I had in front of me. I was expecting those to be in, and we feel that this version is adequate and successfully keeps in place the practices that have been historically in place in the town, and that going forward, the type of relief that people would need is well governed by these provisions. And I want to thank you for all of your time getting the weeds on these things. Thanks, Jack, as well, for taking initiative to push this through. We look forward to a favorable recommendation to the town council. Thank you.
Thank you,
Thank
Mr.
you.
Spear. Any other questions from the board at this moment? Anyone else asked to speak on this? Mr. Michael, come on up.
Identify yourself.
Michael DeLuca, 21 Middlebridge Road. I had a chance to review this ordinance draft and then gave some thought to it. As you know, I've written a few ordinances for the town over the years. And one of the things that I've always tried to do as an underlying objective is to be simple. Make the language direct and have it be easily followed by laypersons as well as attorneys. When I read the text, it seemed to me, first of all, that Ms. McGreen's application was seeking to insert a reference so that applicants could seek zoning variances along with, for non-conforming uses, particularly non-conforming uses that get demolished. Understandable, and I think it would be a good amendment for you to undertake. I did notice that there's that the text was changed to incorporate non-conforming uses as well as buildings, and I saw numerous references to uses. I'm not sure if Mr. McGreen, in the previous meeting, might have explained why that needs to be in there, but that would be a question for me to put out for you all to consider. Also, the revised language, as I saw it, requires that any property destroyed by an act of God, a fire, or something of that nature, would require a special use permit for reconstruction, and I believe under current regulations, Ms. Sable might be able to correct me on this. Under current regulations, if it's destroyed by fire or an act of God, the building inspector is authorized to issue a permit for reconstruction in kind, without the need for a special use permit. That may or may not be correct. I think maybe that question has to go to Mr. Parental. And then the other thing that I was concerned about is that it removes a reference to section 10 of the code, which is a section that sets the standards for issuance of special use permits. So, in my mind, if I were a sitting member of this board, I would want to consider a couple of things. One is, what is the value of inserting the word uses into the various sections of the code that's drafted? Second would be to consider if it's advisable to install a new requirement that buildings destroyed by fire, acts of God, etc., need to seek a special use permit. And third, to consider if the reference to section 10 should be omitted in section 9.2. Because in my read, section 10 is where the standards for granting relief are located. And the language that has been worked through, and I understand it's been agreed to by a handful of lawyers, seems complicated to me, and I think it could all be very easily resolved if all of that, the need for review and zoning board approval or variance could be directed into section 10. So that in all these places where you're making the changes, you could cross-reference section 10 and then make a very simple change to the language in section 10, allowing for variances along with special use permits. It would be cleaner, it would be easier to follow, in my mind. That's up to you to decide. I would, again, ask you to consider whether or not to retain the reference to section 10, revise section 10 to address both special use permits and dimensional variances, not require special use permits for replacement in kind when a building is destroyed by acts of God. And there's one piece that nobody seemed to pick up on, including myself, which is item F there on the right-hand page is very obsolete language, and it would give you a great opportunity here to update that and just clean it up. There is no such thing as the Department of the Environment, and there are no such things as ISDS anymore. So with that, I'll finish my thoughts if anybody has a question.
Questions for Mr. DeLuca? Anybody? Thank you, Mike. Anybody else want to speak from the public? So, can someone, Jack, could you, I don't know if it's you or somebody else, you know, as I look through this, so the first full paragraph on the second page, it says, if a non-conforming use of a building or structure. Okay. No, I'm sorry, it's the third paragraph.
Third paragraph of 9.1?
It's 9.2 on the second page, the second full paragraph.
9.2, second page.
Starts with if a non-conforming use of a building.
Hold on.
It's 9.1.
Oh, 9.1. Third paragraph, a non-conforming use.
I'm sorry, 9.1.2, you're right, excuse me. Yes, if a non-conforming use of a building or structure is damaged or destroyed by fire, explosion, act of God.
Right.
So,
Yeah, so
can you give me an example of a non-conforming use that gets destroyed by fire or an act of God?
I think the Dunes Club, that building at the end of the beach down there, that got washed down, and I think they have 1 year to reconstruct. Would that be a good example?
A real live example or a, well, so yes, except that house was actually in an R80 zone.
Oh, no, that was illegal.
It was a split zone.
It was a
Okay.
split zone, yeah.
Um, gas station located in a residential zone?
Yeah, I could give you a hypothetical of a, you know, a restaurant that you may have seen, that may have just had a Superior Court case, if that were to burn down. Although, that's not a good example either.
No, just, I mean, the word I don't know if it's, the word use is, to me, a little confusing. The structure, you're talking about the structure of the building, that's one thing, but to say that an act of God destroyed the use, just seems a little,
So I'll give you an example of an entire, almost several houses anyway, that are non-conforming. In Jerusalem, on the right-hand side on Succotash Road as you drive down, and as it follows the bend, that's all a BC commercial zone, and it's almost entirely outside of Skips and Gyms and a couple of other ancillary shops, is residential. Those are all non-conforming uses.
anybody else?
I did want to just pick up on what Mike DeLuca had said relative to the special use versus the use. I'm trying to see, I noticed on version 5, I was looking on it, and if you recall in our subcommittee meeting, Wayne was going through there and we changed the word use to special use. I think to tie it back into section 10, I think that's what we were trying to do.
Right.
But I had a notation on my version 5 here, under number 2. I think version 5, we had without receiving, it says a non-conforming building or structure is voluntarily demolished or removed by its owner without receiving, we inserted in the most recent section, a special use. But in my version 5, I had a note that Wayne wanted that changed to special use. But I'm not sure if that, now that Mike brought that up, I'm not sure if we need the word special use in there as opposed to use.
I think what Mike's saying is keep the special use in there, but keep the phrase in there as provided in section 10.
I see what you're saying, yep.
Did I get that right?
Yeah,
Is
in that case there, that Ms. McGreen is discussing, it has to do with voluntary demolition. On the next page over, it talks about buildings that are demolished by acts of God. And the current regulation does not require a special use permit for rebuilding.
Which section was that, Mike? Where were we at?
Okay,
It's item F on the second page. You had renumbered
Hold on.
the section, so I'm not sure.
Jill?
all right, I think I'm following everyone here, if I may, Mr. Chairman. So, under voluntary
Item D.
demolition, I believe Mr. DeLuca is referring to the reference to section 10 that you may want to consider keeping. And under involuntary demolition, where it's referring to a special use permit, but Mr. DeLuca is correct that you are allowed to reconstruct in kind according to building code. You couldn't continue to, be below the floodplain, for instance.
What section is that?
I'm now on involuntary demo, so I'm still in section 9.1. On the next page, Jack, where it's, so the first, if we go back to the first page where it says a non-conforming use of a building or structure is voluntarily demolished. If it was voluntarily demolished, a use, it would need a special use permit. It's a requirement in the ordinance.
Yeah.
And under an involuntary demo, act of God or the public enemy,
Where's that? Which one is that?
that is on the next page, just before letters A through now H.
My concern is with item D.
D, okay. Just be
Where
done.
item D, it should just say
yeah.
permit because it's covered
Yes.
then under letter H.
Yep.
So rather than saying an application for a special use permit, you should say just an application for a,
Permit.
Permit.
yeah. Yeah. Yeah.
Can I ask you a question?
Sure.
This came up at
Right.
one of our other meetings, this reasonable time, what's that? What does that mean?
Where are you referring to?
That same sentence, no?
Okay, Mr. McGreen, you're
Reconstruction
to
is
agree?
commenced within a reasonable time after the occurrence.
Yeah, I have no
What
problem
does that
taking
mean?
out special use, and just making that permit.
Dr. O'Neill, I think that it relates to abandonment of a use. I think that we may, so long as you rebuild or pull a permit and begin your efforts within a reasonable time, it's clear that you haven't abandoned a use that's otherwise non-conforming. I think that's where that language comes from.
Did you answer?
Well, no, because it's come up where you guys, people keep coming back to postpone or extend their permit time. We use terms like reasonable time, that flies, but you're out in the legal world, reasonable time.
That's in the ordinance as it's drafted right now, that's not an addition or a change.
Yeah, so that's,
We have that in there today.
So there are no standards for reasonableness, it's basically whatever the majority of the planning board decides what's reasonable.
It's the standard that keeps many lawyers employed.
Right?
Yes.
We don't want to get rid of that word.
But there are no standards.
It's reasonable, it's based on the facts and circumstances of every case.
Exactly.
we need to go over
The courts have defined the reasonable man standard in numerous cases, so it's common law, it's not codified.
Jill?
Mr. Kelly, I just wanted to get clarification on the previous paragraph for the voluntary demolition, at the bottom of page 1, for those following along.
Keep in as provided in section 10 of this ordinance.
That's the question.
Yes.
Okay.
I think we may have taken it out because we thought it was redundant, or because you're just saying what's already in the ordinance, so why do you need to say as provided in section 10? Because it's in section 10. But either way, I mean, it's belt and suspended, so I don't care if it's kept in there or not.
Thank you.
Okay, so Jill, because you're gonna be the official scrivener of the modifications that have been made as a result of this conversation, let's just go through them so everyone's on the same page.
Sure. So the changes that have been agreed to by the applicant are, and this is the order they occurred. This is adding back letter H, which is in version, yep, which is in version 5, and I'll read it for you if you like.
Yes, please do, Jill.
Which is letter H, which is in 9.1.2 for involuntary demolitions. Letter H says the applicant shall have the right to seek dimensional variances, modifications, special use permits, and/or staff approvals.
So the way we had reworked that,
Yeah, you got, yes, absolutely, Mr. Friday, I know where you're going.
I heard that.
The applicant shall have the right to seek relief from the ordinance, is that
from
correct?
the zoning ordinance, yeah, it's just
Thank you.
consistent with the rest of it.
Yeah,
I'm sure I have it
alrighty. Section 9.2.3, I believe would revert back to version 5, which is if a dimensionally non-conforming building or structure is demolished or removed by its owner, it shall not be rebuilt or replaced, except in conformity with the dimensional requirements of this zoning ordinance. I should say ordinance, and it might say it in a new one. Unless there is no increase in the dimensional nonconformity, or, do you have a newer version, Mr. Friday?
Yeah.
Read it, please, thank you.
So if a dimensional, this is beginning, if a dimensional non-conforming building or structure is demolished or removed by its owner, it may not be rebuilt or replaced except in conformity with the dimensional requirements of the zoning ordinance unless the owner obtains relief from the zoning ordinance prior to demolition or removal.
And that is version 5.
Yep.
Thank you. We are going to revise letter D in section 9.1.2 to remove the phrase special use. And the applicant has agreed to add in the phrase as provided in section 10 of this ordinance in section 9.1.2 regarding voluntary demolitions.
And section F, we're gonna update the OWTS
Oh, yes.
proposition.
Yes, so that'll say, right, so that'll say on-site wastewater treatment systems for the Department of Environmental Management.
Where's that again?
F, I'm sorry, 9.1.2, non-voluntary,
Oh, I see, we're on the department.
It's just fixing the language.
So those are 5 changes,
correct,
correct?
yes.
fix that.
Take out ISDS and make it a.
On-site wastewater treatment system from the Rhode Island Department of Environmental Management.
Okay, we got them all.
I believe we do.
Jack, you're in
I'll-
agreement?
I'll send it to you tomorrow, I'll do it tonight so I don't forget. I'll send it to you.
Okay. Thank you.
Okay. Any further questions or discussion? Is there a motion?
I have a motion, Mr. Chairman.
Proceed.
I move that the planning board recommend the town council adopt the proposed changes to section 9, non-conforming structures of the zoning ordinance, with the revisions as discussed and agreed to by the applicant today. And findings, Narragansett's existing zoning ordinance, section 9, non-conforming uses and structures, is strident and does not explicitly allow for property owners, applicants to seek relief via variances and modifications. In practice, at least in recent years, the town has allowed property owners to seek relief for dimensional nonconformity for existing nonconforming structures and for the demolition or replacement of existing nonconforming structures. A recent Rhode Island Supreme Court decision has stopped the issuance of variances for non-conforming uses and dimensions when they are not explicitly authorized in the town's zoning regulations. The proposed change to Narragansett zoning ordinance proposes to codify the town's recent practice of permitting property owners, applicants to seek a variance for expansion or redevelopment that are dimensionally non-conforming. A planning board subcommittee met with the applicant, 2 assistant solicitors, director of community development to refine the draft and develop consensus on wording for this zoning ordinance revision. The proposed draft codifies recent practice of allowing property owners, applicants to seek a dimensional variance. And the proposed draft also corrects some internal inconsistencies and clarifies the existing text. And finding that it's consistent with the comprehensive plan. Goal, land use. 1, make local land use decisions in an open, transparent environment based on sound planning principles with the most accurate and available data, because the variance process provides transparent process for making land use decisions. Land use 1.1b, amend zoning ordinances to be consistent with future land use map and the intent of the comprehensive plan. And land use 1.1c, review and update regulations in light of new legal developments, because this is amending the zoning ordinance in response to recent Supreme Court decision in a way that is consistent with the comprehensive plan, because it clarifies the process for expanding and redeveloping non-conforming uses and dimensions. Land use 2, promote sustainable growth that builds on Narragansett's distinct character, and 2.2, promote residential development that strengthens neighborhoods, respects natural resources, preserves open space, avoids sprawl, reinforces community character, because the result of this change is to require variance for expansion or redevelopment of non-conforming uses. Expansion and redevelopment of uses have the ability to impact neighborhood character and affect the development's impact on water quality and health of salt ponds and Narrow River. Ensure, oops, where am I? Protect the unique character of Narragansett's neighborhoods, which is H2, and H2.2, support residential infill and expansion that is sensitive to surroundings and does not negatively impact neighborhood character. That's the revisions clarify the requirements and review required for redevelopment of non-conforming structures and uses, and they establish the variance process for these developments, which can help to maintain neighborhood character. Where the amendment will affect the town's land uses, buildings, and facilities. The proposed changes to the zoning ordinance will result in variances for the expansion and redevelopment of buildings that are non-conforming These buildings will be larger than the existing non-conforming structures. How and where the amendment will affect the town's natural water resources. Many of the non-conforming structures in Narragansett are on substandard lots. These are non-conforming because the state and town recognize the detrimental impact of the extensive development in shoreline areas on the water quality and health of salt ponds in the river, and revised zoning to protect the water quality. The amendments explicitly provide for variances that will result in expanded development on lot-by-lot basis and the cumulative impact of the expanded development. Whether and how the amendment will affect other regulations. The proposed text will eliminate the prohibition for property owners, applicants with non-conforming uses and structures from obtaining variances and other relief for expansion or redevelopment of non-conforming uses and structures, and recent changes to the setback and lot coverage standards for substandard lots have reduced the number of structures in Narragansett that are non-conforming structures. The revisions to the zoning code to explicitly provide a process for property owners, applicants who want to expand non-conforming uses is in addition to those recent changes. And then consistency with the proposed purposes of zoning, providing for orderly growth and development which recognizes goals and patterns of land use contained in the comprehensive plan, the natural characteristics of the land, including suitability for land based on susceptibilities to surface pollution and values of unique valuable resources. Because establishing a variance process ensures review of proposals to expand or redevelop non-conforming uses and structures, ensure that they are consistent with the comprehensive plan, neighborhood character, and can address the impacts of water quality runoff that impacts salt ponds in their river. And then provide for efficient review of development proposals to clarify and expedite zoning process, amending the ordinance to allow applicants to ask for relief from the zoning ordinance instead of prohibiting the request altogether is both expeditious and efficient. And then finally, providing procedures for the administration of the zoning ordinance, including but not limited to variances, special use permits, and procedures for modifications. And recent practice of the town has been to allow applicants to seek variances and other relief on a project involving voluntary demolition, reconstruction of non-conforming structure. This zoning revision codifies this practice.
Thank you. Is there a second?
Second.
You couldn't find any more? Jeez.
Sorry, I'm thorough.
Discussions? Anyone have anything to add at this point? Ready to vote? All in favor?
Aye.
Opposed? 5-0.
Thank you, Mr. Chairman.
Thank you.
Go in peace.
All right. I think I'd like to move back to this. Would be all right? Is this just showing that? Okay, Mr. Surratt, you're up. You're up.
Steve, you're up.
You're up, Steve.
I'm sorry, I couldn't hear, I was.
We're
They could hear you. That's the reason why I told him he was up.
Good evening, gentlemen, and thank you for the opportunity to appear tonight. I am coming back and forth of this board for an application that I had the pleasure of dealing with approximately 2 years ago. It is, and actually with Mr. DeLuca, I think it was towards the end of his tenure. It is, our plan is to subdivide this lot here that you can see. We went through extensive plans and that were approved by this board. We're asking for an extension of the approval as we have not finalized the plan. We're still going through some CRMC and DEM regulations. And, excuse me, part of the plan also requires some modifications to the existing house so that it is in conformance with all proposed zoning ordinances and setbacks. So I would believe the first request is by right, and I would make that request tonight.
Thank you, Mr. Surratt. Questions?
Well, it comes up to a whole reasonable time, certainly. I don't have any problem with extending it For how long?
How
A
long?
year, 2 years?
I would request 2 years, but I
Two?
defer to the board, 2.
Mr. Chair, I believe, listen, I believe that the by right is
Is it
one
one
year,
year?
and then you have the right to come back a second time for a second 1 year.
That's my understanding as well.
If the board is more comfortable with 1 year, I have no objection to that.
2 total, but we'll see in a year.
It's fine with me.
Right, 3
You around with that?
Yes.
Okay.
That's reasonable.
It's always try to, Dr. O'Neill. I know it doesn't always come across that way, but I try.
So do we have a motion?
I'll make a motion to grant the 1 year extension, which is required by statute to be granted.
Second.
Any further discussion? All in favor?
Nobody's interested in 2 years? You guys applied to CRMC lately?
Well,
We're gonna see them again. I'm just trying to take stuff off the staff's plate here, we got a lot of
You know,
stuff.
for discussion, this brings it back to the due diligence, that they're actually moving forward. I believe the statute is when there's no activity or limited activity, but maybe out of abundance of caution.
I think your approach, Mr. Grundy, is what I've done in the past. I think that's the best approach.
Just asking. As a guy who's applied to CRMC,
I like seeing Mr. Sedano.
I like him
Always
too.
to come down and say
I like
hi,
him too. All right.
especially on reasonable proposals, as Dr. O'Neill said.
Okay. I think there's a motion that's been seconded. All in favor?
Aye.
Thank you all.
See you.
Have a great evening.
You too.
Nice to have a short meeting, I'm sure.
What was up to us?
Okay, the hold on new business.
Oh, yeah.
It's over now, so I don't.
Jill,
Yes,
we just granted a 1 year extension on Mr. Surbett's
great,
client, okay?
thank you.
We're on to new business. So we have a discussion of brief discussion, hopefully, with town council's February 2nd, second reading and adoption of the 15% dimensions of the zoning ordinance. I don't know if any of you were present or have seen the tape, but the council moved forward and adopted the changes without modifying or explaining the language that was in the beginning in terms of that none of the lawyers could tell us what exactly it mean and where it applied, number one. Number two, the Breakwater Village language was not modified. And three, what was the third issue, Jill?
It was Breakwater Village, it was the safety issue about the side yard setback.
The 5 yard setback.
5-foot setback, yeah,
in the side.
correct.
So in the discussion at the meeting that evening, Council President Menzies said those are important issues that Mr. Friday had reminded them of at second reading, which they had been told about as part of our report when we made it. So the question I think on the table for this board, and Menzies also said that we should take a look at those things. We're not going to stop final passage tonight, but we should look at those things and make a decision in terms of whether to modify the ordinance to take care of those things as well. So, Jill, have we heard anything further from Breakwater Village in terms of what they're looking for?
Sure. So the short answer is I haven't received anything directly from them. They had emailed the town council twice, once prior to the closing of the public hearing and once between the first and second reading, and asking if the council would be making amendments before the second reading. I reached out to Mr. Pimentel today to inquire again, and he did send an email to the president of the Breakwater Village Condo Association. So, and I know they've said it, they've said it here, they've said it to council twice. They're not here today, but I do expect to have an email back from them probably by tomorrow, or it could be in my box now, for all I know.
The process for addressing, should this board decide it wanted to do something about any of those things, the process for doing so is what?
So an amendment to the ordinance can happen in three ways. It can happen from the council where they want to make an amendment and they refer it down to you. It can come from an applicant such as Mr. McGreen. And then this board can, in its due diligence, for instance, every year we get a new package of changes that come from the state, and the amendments are born from this board, and then they go up. And in this case, it came from, I'm sorry, Mr. McGreen's case, it was born by the applicant. So there's three ways. This board can make recommendations to the town council. You are, in that capacity, you are a recommending board to the town council.
No, I don't know that we need to make a decision to do anything tonight unless someone's got something specific on their mind. I think I'd like to see some further communication with the folks from Breakwater Village before we address that issue, but that seemed to be from the vantage point of a constituency out there looking for help. That's one constituency out there. The issues, the one, and I don't know how to deal with the language that we never got an answer to with respect to high water, that was placed in the high water table section, but it clearly could be interpreted and construed to be applicable in just about any place in town. And it seems to me that somebody, whether it be this board, ideally the town council, would get clear on what that language really means and what its intention was. Absent that, I'm not sure what to do with that. And then finally, on the 5-foot setback in terms of the fire safety, I think that's an issue that's been of concern to this board for quite some time. We might want to originate something ourselves. Think about that over the course of the next month, and if so, come prepared to make a recommendation on that issue going forward and get consensus to do so. Does that make sense, gentlemen? Does that make sense? Okay. So we will leave it at that. Would like to add it as a matter of old business to the next agenda when we come together in March. On to the approval of minutes. I'd like to do them all as one block, but we can't because some people were not members, some people were absent, including myself. So we're going to have to go through them, I think, one at a time.
Read that, Rupert.
You got everything going on.
So let's start with the meeting minutes for Tuesday, October 21st. Are there any suggestions, modifications, or changes? Hearing none, I'll take a motion to approve the...
I move we approve the Tuesday, October 21st minutes as submitted.
All in favor? I can't vote, and neither can Jim.
And who? And you can who?
Jim can't, and I can't vote. Jim wasn't a member at that meeting.
But he is now.
You can't approve the minutes. You can't approve the minutes for me. All right? So I'm abstaining, as is, I presume Jim was.
Yes.
Okay, next is the meeting minutes for Tuesday, November 18th. Are there any suggested changes, modifications? Hearing none, I will...
Mr. Chairman, I move the minutes for Tuesday, November 18th as submitted.
Second.
All in favor?
Aye.
Aye.
Opposed? Jim, you remember that meeting?
Yes.
I have a 5-0 on that.
5-0 on that one. Next up is Tuesday, December 16th. So,
Mr. Chairman, I have an addition to that.
okay.
I think it's important under the section E1. We had a discussion, as you just mentioned, we asked the assistant solicitor about the meaning of the language added to that ordinance, and was not able to get an explanation. And there were two attorneys in the audience that night as well who we asked if they understood it, and they also said they didn't understand it. And I think that should be reflected in the minutes.
So
Sorry, say that again?
There was language added to the, I don't know what you call that, the zoning ordinance we were looking at. that was new language that had not been previously, and we asked the solicitor to, if they could explain the meaning of the
Right.
minutes,
Okay.
and they could not, and there were two other attorneys in the audience that night, and we asked them if they understood it, and they also did not understand
Okay.
it.
Okay, I'll
So
make those.
you want to add that under E1? Is that what you're
E1,
saying?
yep,
E1.
yep. I think we
Can I get a continuation of that? Because I'd like to
Sure.
see that, because
Sure.
if there are attorneys that spoke and I didn't write it, there's got to be a reason why.
Yeah, they were in the audience, they didn't go to the podium, but they were there.
Okay. If
Are
they
you
had,
asking for time to frame that question and modify the minutes accordingly?
yes, please.
Okay, so we had a motion to approve, someone
I moved,
withdraw the motion?
I didn't move to approve.
Okay, so why don't we,
I moved them,
we'll move to continue,
move to continue this minute,
the approval.
December 8th, December 16th.
Second. All in favor?
Aye.
While we're there, Nick, can you help us with this one?
Yeah, I can reach out to the drafter. I'll see what I can figure out.
Yeah.
Just, you shoot me a note with what the language was. I know we talked about it. If you could,
Okay.
actually, no, Jill will get it for me. Let me see what I can.
Yeah, this is,
I can tell it's
there's
bugging.
no reason why it should be a mystery.
I can tell it's bugging. I'll
You
see
know?
what I can.
Well, it also irks me in that council members were talking about the complexity of our zoning ordinance and it being hard to understand. And here we're adding language that nobody understands or can explain, so.
Thank you.
Good point.
Oh, thanks.
All right, on to the meeting minutes for December 22nd. Any suggested changes, modifications?
Chairman, I want to add a similar language to that discussion. We asked the solicitor again, and I believe that night it was Nick.
It'll be under part 2, on page 1, the bottom there, part 2. final
It
order
really
limitation.
is at the beginning of the, it's at the beginning of the.
It's underneath, it's in
Is it
section,
under?
it's in section,
Okay,
it's in
yeah,
section
so that's
4.1.
where it would be, you're
Yep.
correct. And then there is a typo on page 2, under part 10. It says page 8 or proposal, it should be 8 of proposal.
Wait a minute, say,
Uh,
page, okay. Yep, I
Under
see
part
that.
10, yep.
Jill, you similarly want time? on
I'm
this one?
Heidi.
I mean, Heidi, I'm
Um,
sorry. Do you similarly want time on this one?
No, could you just repeat your first one though for that? What was it?
Again, we asked,
It's the same issues
and I believe
one
that
of the
they.
prior minutes.
I believe that-
Okay, yes, can we continue that,
We'll
please?
Yeah.
continue the 22nd.
I believe that number was Tom.
I'm sorry, can you?
I believe you were the one that asked the second meeting about that.
Correct. All right, so now we're on to January 12th.
I think we're gonna move to continue the
Yeah.
22nd. So moved.
Second. All in favor?
Aye.
Thank you.
January 12th.
On to the 12th.
I have a minor edit, I think, on page 2, under Gail Halleck's comments. The last sentence attributes to Gail that she highlighted that 15% of the variances and special use permits came from Breakwater Village. I believe I added that text. I don't think Gail said that.
Okay, I will, yeah, I'll check that. Okay, I'll make note that you made that.
So with that correction, do you move?
Do you,
Yep, I'm
Okay.
comfortable with that.
with that correction, I recommend adoption of the approval of the January 12th, 2026 meeting minutes.
Is there a second? All in favor?
Aye.
On to January 21st. Any suggested changes or modifications on the 21st?
I have another modification on this one, sorry, Chairman. Under the zoning ordinance, I think we should reflect that we created a subcommittee with me and Mr. Grundy.
I'm sorry, for which one, the D or E?
It's E,
Okay.
Yep. We formed a subcommittee with me and Mr. Grundy to meet with the applicant and other attorneys to refine the language, and the intent was not to delay, to do it quickly so we didn't delay the process.
Okay, I'll make those edits.
With that change, is there a motion to approve?
So moved.
Second.
All in favor?
Aye.
All right, that takes care of minutes, mostly. Thank you very much, Heidi.
Yes.
On to reports and updates from staff, council, solicitor, and board. Coastal Access Improvement Committee?
So this month and last month, they are meeting simultaneously, so I haven't been able to attend the last 2 meetings.
Okay. Although I do see there was a proposal last night to the town council, which I presume they passed. that
It did.
Had to add 50 or 75 spots for members of the Narragansett
Yes, yes.
75.
They have
75?
75 parking spaces.
as part of the, okay. Anything from the Land Conservancy trustee?
We're meeting tomorrow. I'm not coming. I'm not driving back for that one. Once is all you get out of me for this week. So I won't have an update this week or next month probably. But
Did you want to add anything, Jill?
The land trust is moving along. They're looking at property acquisition. They're looking at, tomorrow, they haven't met on it yet, but one of the things on their agenda is to talk about effectuating one of the bullet items in the Middlebridge Conservation Land Management Plan, which is to come up with a sort of a site-wide use or a site-wide scope of how to use the buildings on those two lots. So that's all I can think of off the top of my head, but I can certainly give you the report next month in lieu of Steve.
thank you.
Okay. Legislative updates. Zoning ordinance. You want to say anything about zoning ordinances?
Sure. Currently, I received comments from both Rupert, Mr. Friday, and Mr. Callahan, who are members of the subcommittee. I have created a clean document of all those comments and some of my own, and I will be forwarding it to Nick, Mr. Slitro, tomorrow for his review, and we'll meet on that and discuss it. And then we'll come back and we'll have a final meeting and hopefully have a final draft in front of the board for review and recommendation.
What do you think the likelihood is that we could have, the likelihood, and given what else is on the agenda for March, we could have it for March, at least a draft for March for people to review?
It depends on availability of people to be able to meet, so, I mean, we could pencil it in. We can try. It depends on how lengthy my conversation with Nick is as well. You know.
Okay. Well, to the extent that I can encourage, this one's been hanging fire for a while. It would be helpful, Nick, to the extent that we can get you and Bob to focus on this over the course of the next couple of weeks, to have it, at least a draft ready for the board, not necessarily to act on, but at least see and take home with them if they need to. I mean, I'm going to take home with them if we can't discuss it at the next meeting, with the objective of having it done in April. Okay?
Got it.
And then, and that's something that ultimately is going to go to the council, correct?
Yes.
Okay. And do you want to say anything on subdivision regulations, Jim?
Sure, absolutely. So I believe last month I mentioned that I was going to go through. It's right now, it's half in track change, mostly in track changes, some not. So for those of you who aren't aware, the subdivision regulations right now have 4 different types of changes. So they have all of the Scribner's errors from things that were missed in 23. They have, it has all of the draft changes from 24, and then it has, and that's all in one format. And then in strikeout, and then in red line and track changes, we have the changes from 25 that Rupert, myself, and Tom have been working on. I am in the moment right now trying to convert all of that over so it doesn't look like 4 different pieces. It all looks like one cohesive change. I will have a copy to you folks to go ahead and take a look at for next month. I'll have it to you beforehand. And then whenever you're ready, you're feeling comfortable, we'll go ahead and set that public hearing, because it is a public hearing with this board to discuss. I'd like to get it out there. I'd like to get it to you, and then I'd like to have it out there for public comment. And I'll make sure it gets out and advertised on our website and on our socials for public comment.
And again, is there a need for legal review on this one as well?
Oh, definitely, yes. So we did meet with Mr. Craven one time. He did come to a subcommittee meeting. But there are still some outstanding questions about, and I'll have those called out. Likely I'll get it to legal ahead of time with those call-outs. If I could meet with the subcommittee one more time to just hone those in and then give them the full draft so they can bless the whole thing.
Okay, so just from a process point of view, you prefer to do that? Have the board subcommittee look at it and then pass it on to legal, rather than having everybody sitting together and getting it done?
Well, I would kind of put that back at you. Would you rather have legal's comments ahead of time, so as a subcommittee, so that when it came to the 5?
Yes.
Okay, then yes.
Okay.
Is that a trick question?
Not yet. Okay, now this is clearly Freudian. This is not about a compressive plan, although it might be compressed. It's about the comprehensive plan. Jill, would you like to?
Yes,
Tell
absolutely.
us where we are, please.
Yes, so I think I provided you an excerpt of the response that we received, and ultimately, I believe I've already mentioned this, but Weston and Sampson was awarded the contract. We actually have a kickoff next week. The contract finally went to them, and we're gonna do a kickoff next week to talk about, and one of the things in the kickoff, and I think it's in the paperwork that I gave to you, is to come up with that draft scope and schedule, and then we're gonna throw at them any documents that they might need, and then they're gonna give to us kind of a working document and how we're gonna lay out the next 18 months. And that's,
No, it's good, the process got quicker than the last 10 years.
well, the last time, Dr. O'Neill, as you may recall, it was 5 years. So we have until 2027 until our plan expires, and the statute, as it's written today, gives you like a 2-year grace period before you can't use the comprehensive plan for land use decisions. So I don't know if that's going to change. I'm aiming for 2027.
So in terms of getting the board kind of clued in and up to speed, do you think after this meeting there will be agreement on what I'll say scope, timetable, kind of not necessarily written in concrete, but a kind of a structure for moving this thing, an organization for moving this thing forward in terms of how we're going to do that?
Yes, so I provided you the scope already and the tasks as they outline them. I think this is going to be more of how we work together.
Right.
Do you want to meet virtually? Do you want to meet? We are in another grant right now where two grants. We have one. We meet every other week. We have a half-hour check-in meeting. So that's a lot actually. But this might be every 3 weeks or once a month, depending upon who the steering committee is and who's going to be that on that sort of day-to-day. Obviously, staff will be, and we need to decide internally which staff are going to be at the table outside of the planning department. Of course, we will be there, but if it's a rotating staff, if we're talking about transportation circulation, do we want DPW at the table? If we were talking about facilities planning, do we want engineering at the table? It may be, and that's one of the things I think we'll figure out at the kickoff, is how we do that. If we're talking about open space and recreation, we probably should have the Parks and Rec director.
I guess the message is, it's kind of been lurking in the background, but it's coming out of the shadows. It's probably going to be a regular part, a component of the work of this board over the course of the next couple of years.
Yes, it will be. And I would say, be prepared for that as much as you can be, and I would ask you to anticipate having special meetings. The last process I went through, it was 5 years and 32 meetings. So some of them were done concurrently as a regular planning board meeting, some of them were done specifically for the comprehensive plan, and that includes the workshops and the hearings.
Any questions or comments for Jill?
The only thing I would say is the last time I went through a comprehensive plan rewrite, it was one of the few benefits of COVID was that we were able to do a lot of the meetings by Zoom. And I don't know if we're allowed to do that for subcommittee meetings or not, but it did seem to give the person steering the meeting a lot more control and kept it focused and moving. So I don't know if that's...
As a subcommittee, you could, Mr. Grundy, but not as a board.
Yeah, so the subcommittee meetings, I don't know if that's an option or not.
Well, we haven't set a subcommittee right now. We have the internal staff and who we're going to pull in. I did talk to Mr. Callahan. He is going to come to the kickoff. And that would be one of those things that come out. Do we want a subcommittee of this board? And it sounds like maybe that's what you did in North Kingstown. And if it worked well, we'd love to hear about that. And if that's something that this board wants to do, we could put 2 members on that working committee.
Well,
it's a lot of work.
Let's have the kickoff meeting first, and then see where we are at the end of that meeting in terms of how do we think about getting from point A to point B as far as we shine the light in the darkness as far as we can.
You bet.
Anybody else? Okay, we have a meeting coming up, as we talked about earlier tonight, on St. Patrick's Day, on March 17th. I presume everyone's going to be here?
I'll be here. My wife will keep the corned beef and cabbage on the burner. I'll be all right. She won't be happy, but...
So it sounds like you have a quorum.
Thank you.
Heidi. And with that, unless there's anything else to come before the board, take a motion to adjourn.
So moved.
I guess people want to stay. I haven't heard.
Second.
All in favor?
Aye.
We're done. Thank you.
Nice work.